well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Cam & Company, where unfortunately we are talking about some infringements today. Yeah, New Jersey Governor Phil Murphy has signed that carry killer legislation at a public library in Scotts Plains, New Jersey, joined by gun control activists from Moms Demand Action, Giffords, and others. I guess Phil Murphy was looking for a gun-free zone to sign this concealed carry legislation. I mean, there's no shortage of places that are considered sensitive under the new law signed by Murphy today, public libraries included, but he could have gone to any New Jersey diner, any self-respecting New Jersey diner, because the good New Jersey diners all have their alcohol licenses, and you can't carry in places in which alcohol is served. Even if you're not drinking, diners, the vast majority of them in New Jersey anyway, are off limits, as are a host of other public places and private property too. Just like New York, New Jersey's bill banning concealed carry on all private property by default unless the property owner opts in and specifically puts up signage permitting concealed carry. Not generally how you treat a general right to carry in self-defense in public, as the Supreme Court described the scope of the Second Amendment in Bruin, but as the head of the Association of New Jersey Rifle and Pistol Clubs, Scott Bach, told us earlier this week, this bill is not an attempt to abide by what the court said in Bruin. Instead, it is a giant middle finger to the Supreme Court, and honestly, to law-abiding New Jersey residents. That's the thing. You know, I don't think the justices on the Supreme Court are going to lose too much sleep or feel bad. I don't think, Justice Clarence Thomas is going to have his feelings hurt by Phil Murphy signing this bill into law today. The people who are going to be hurt are the good people in New Jersey who are and have been unable to protect themselves against violent criminals who thought that maybe the state would recognize their right to armed self-defense, only to be told that, no, actually, that's not going to happen. In fact, arguably, we're making things even worse, right? Sure, you might be able to get a concealed carry license if you jump through all of the hoops and hurdles, if you pay the additional fees that we're charging now in order for you to exercise a fundamental right. But once you get that license, it doesn't really matter because you can't really carry anywhere anyway, right? I mean, it's absurd. Now, again, according to Scott Bach, litigation is expected imminently. Now, the holidays may throw a bit of a monkey wrench into the works here. It might take a couple of days for that lawsuit to be filed, unless they can get it in this afternoon or perhaps tomorrow. But we do know that litigation is on the way. We also know that the Supreme Court has been asked to consider New York's post-Bruin laws. That request to the Supreme Court coming on Wednesday, and we don't know yet whether or not the Supreme Court will agree to take up New York's post-Bruin gun laws now in the very early stages, or whether they will wait for the legal challenges to go to trial. Fingers crossed, and I think every gun owner out there and every Second Amendment advocate is hoping that the Supreme Court is not going to wait, not going to delay, that they will step in and say, hey, remember what we told you just a few months ago? No? Well, go back and read it, because we're going to put an injunction on all of the provisions of the Concealed Carry Improvement Act. Again, that's what we're hoping for. And I think even that's the expectation, not just the desires and hopes of many gun owners, but I think that that's the expectation, that New York flouted what the Supreme Court said in Bruin, and now it is up to the Supreme Court to smack those restrictions and those infringements down. If that happens in New York, it will not immediately impact what's going on in New Jersey. New Jersey's in the Third Circuit Court of Appeals. New York is in the Second Circuit Court of Appeals. So different appellate courts. And so it would not immediately implicate New Jersey's laws. However, if the Supreme Court does intervene and tell New York, hey, listen, you can't enforce any or all or some or all of the provisions of the Concealed Carry Improvement Act, that would be a clear signal that many of the virtually identical provisions in New York's law are also on very thin constitutional ice. So keep your eyes peeled over the next week or so. We will be covering the latest events at Bearing Arms, and we do expect that there will be some news to report on next week, even though typically the week between Christmas and New Year's things kind of settle down. That might not be the case. In fact, it probably won't be the case when it comes to our right to keep and bear arms. But as Murphy is signing this anti-civil rights bill, gun owners across the state of New Jersey are speaking out. And I got to say, I was actually really surprised to see this report from WHYY, public radio, in Philadelphia, with a story on black gun owners in New Jersey objecting to the new concealed carry restrictions. Public radio is not generally where I expect to hear the pro-Second Amendment side of the argument. And yet, tip of the hat to WHYY for actually covering and reporting on what these gun owners have to say, including Leon Grauer, who is a Newark-based attorney, organizer of the New Jersey Black Gun Owners Association, who says that the rise in gun ownership among black Americans likely sparked by incidents like the murder of George Floyd, as well as the desire to defend themselves from violent crime, especially in what he describes as underserved communities. He said a lot of people within the black community perceive incidents, such as the killing of George Floyd, and other incidents highlighting their need for personal protection. Also, he says in cities that have high crime rates, particularly high violent crime rates, just as in the white community, people feel empowered to defend themselves. Many people in the black community feel empowered to have a firearm to defend themselves. Now, don't forget, we actually had New Jersey lawmakers specifically saying, do we want anybody in Paterson or Camden or Trenton, all minority majority cities, by the way? Do we really want any of those people in those cities to have guns? We want any more people carrying guns around in those cities? Yeah. Yeah, actually you do. Because if they want to carry a firearm in self-defense, it's their right to be able to do so. So do you want more people in Camden to be carrying? Well, no, clearly you don't, anti-gun lawmaker. But that doesn't matter. Do residents in Trenton, in Camden, in Paterson, in Newark, in Jersey City, hell, in Metuchen or Red Hook, do they have the right to carry a firearm in self-defense? And the Supreme Court has unambiguously said, yup, they sure do. But again, New Jersey Democrats thumbing their nose and flipping the bird at New Jersey gun owners and all those who would try to exercise their right to keep and bear arms. Grauer went on to say that he knows many responsible gun owners in his community who value safety and regulations that don't infringe on people's constitutional rights. He says many members of his organization believe there's a common misconception that many New Jerseyans who come from marginalized communities are against gun ownership in general. He said historically, ever since slavery, firearms have been a means of self-defense and self-preservation for black people in America. There's a perception that perhaps during the civil rights movement in the 1950s and 1960s, black people in America en masse put down their guns and lived by a nonviolent strategy, but it's far from the truth. He said the nonviolent movement was protected by groups of black people, black gun clubs in the South and elsewhere, who either made their presence known or outright surrounded or stood guard for a protest. And that is true. But there were also many individual acts of self-defense. It wasn't necessarily, chapters of the NRA, which actually we saw in North Carolina. Black gun owners becoming NRA members, getting access to firearms, and again serving as a collective group of self-defense. But you also had individuals like Fannie Lou Hamer, who talked about having a shotgun in every corner of her house in case the night riders of the KKK showed up outside of her door. It's not just collective self-defense. The right of individual self-defense has been practiced as well. Again, for really as long as this nation has been a nation. Black Americans, oftentimes with great difficulty, but they have been able to access, in some cases, their right to keep and bear arms. And we've been working towards that more perfect union where Americans of every race, color, and creed can have access to that right. I've actually been reading, because I'm a nerd, a book here, Negro Militia and Reconstruction by Otis Singletary, which is fascinating. Written in 1957 by a professor at the University of Texas. I will say it has a bit of a viewpoint. But one of the things that I have learned when I'm reading this here is that, in many cases, the militias that were formed after the Civil War in the Reconstruction South, in many cases, those militias were largely comprised of Black Americans, newly freed slaves in many cases, in some cases of folks who had never been enslaved, but were now, again, trying to exercise the full flower of their rights as American citizens, including their right to keep and bear arms. And you learn that the post-Civil War gun laws in the South, again, were aimed at depriving those newly freed slaves and other Black Americans of their Second Amendment rights. At one point in 1875, there was a conflict in Mississippi. At that point, it was largely between two groups of Republicans, two wings of the Republican Party. And it nearly came to, I think it did reach the point of civil unrest. It nearly reached the point of mass violence before there was a peace agreement of sorts that was signed. And one of the things that the incumbent governor of Mississippi agreed to in that peace agreement was the disarming of the Black militia. He had argued, okay, listen, we'll disband the militia, but I want them to keep their guns. And his opponent said, nah, it's not going to fly. And so the militia was disarmed of their firearms. And the next election, by the way, Democrats took control, a lot of violence at the polls, a lot of voter intimidation, and they maintained a lock grip on the state government of Mississippi for 90 years, including the passage of all kinds of Jim Crow laws, including some that were aimed again at restricting the right to keep and bear arms. Well, it's not the 1870s anymore, but we still see this type of, if not quite as blatant, this type of hostility towards lower income Americans, towards racial minorities, to those who, let's say, the establishment might view as not responsible enough, right? Not the right type of person to carry a firearm. We got to do something. It's that soft paternalism breed of racism that we see here, but it doesn't make it any better. Another individual that WHYY talked to in New Jersey, Douglas Worthen, firearms instructor in Irvington, who argued that historically gun laws in the U.S. have targeted and criminalized minority communities, and that some of New Jersey's recent gun restrictions are no exception. WHYY actually said historians recently have uncovered how the Second Amendment and several gun laws enacted around the country's founding were rooted in racism. Worthen said Black ancestors at one point couldn't even possess any firearms at all. The infringement on people of color in this country has been around for a very, very long time. It still exists present day, but it just has a different form. It does. I would argue, by the way, that it's not that historians have just recently uncovered this, although the scholarship of Nicholas Johnson of Fordham University with his book, Negroes and the Gun, is absolutely fantastic. That is one of the books that every gun owner in the country should read. I would also add to that to Charles Cobb's This Nonviolent Stuff Will Get You Killed, which is a history of gun ownership and the right to keep and bear arms during the civil rights movement in the 1950s and 60s. Another excellent bit of history that every gun owner should know. But Worthen is right that we do still see, perhaps again, not the same language, but taking a different form. And in some cases, these Jim Crow laws are still on the books. In North Carolina, the permit to purchase system was put in place back in 1919 at the height of the Jim Crow era. There's been scholarship showing that to this day, Black applicants for a permit to purchase, which is, again, required in order for you to purchase a handgun in the state of North Carolina, are denied at nearly 3 times the rate as white applicants. Now, again, on its face, this permit to purchase statute is racially neutral. In practice, it's anything but. And I have a feeling that that is actually going to be the case with these new restrictions in New Jersey, too. New Jersey doesn't have a host of Second Amendment sanctuaries, but I have a feeling that these new gun laws are going to be enforced more frequently in the very cities that New Jersey lawmakers highlighted in their opposition to allowing folks to exercise their right to armed self-defense. Arrests in places like Patterson and Camden and Trenton and Jersey City, places where, again, violent crime is higher than the state average. But I would argue that that means that people have perhaps more of a reason to want to carry in self-defense than they would if they live in a gated community in Cherry Hill or someplace like that. Again, it is a sad day in New Jersey. It really is. I didn't have any hope that Democrats would do the right thing here in the wake of the Bruen decision. It's not where they are. In many cases, not who they are. They view our right to keep and bear arms as a fundamental wrong, as a stain on the Constitution and the Bill of Rights. Something that they would love to repeal if they had the votes, but they will try to ignore as much as possible in the meantime. Not even ignore, because ignoring the right to keep and bear arms would actually be better than what they're doing. They can't repeal the Second Amendment. They know that. So instead, they want to make it meaningless. If they were just ignoring our right to keep and bear arms, that'd be fine, right? Instead, they're still targeting our right to keep and bear arms. They're arguing in court, in state houses, and in the public square that the text of the Second Amendment is meaningless, that the history and the tradition of our right to keep and bear arms means nothing, that the only thing that matters is putting in place these common sense solutions that they promise will make our country a safer place at the expense of your ability to protect yourself and the people you love. I don't buy it. And like you, I am hopeful, cautiously optimistic that the Supreme Court is going to step in here, first in New York, and then in other states around the country, including New Jersey, and make it abundantly clear that these post-Bruen infringements can't stand any more than New York's and New Jersey's may issue carry laws could withstand constitutional scrutiny. But again, we will continue covering this story in New Jersey, as well as paying attention to what's going on in New York. We'll give you any updates as they become available at bearingarms.com. Right now, let's turn our attention to today's Armed Citizen story. Our good deed of the day and our recidivist report. We'll start there with a story out of Las Vegas, where an 18-year-old who admitted to shooting a man outside of a drugstore on the Las Vegas Strip was sentenced this week to probation. That's right. 28 to 72 months probation, but probation nonetheless. And it gets even worse, honestly. Joshua Estrada was 17 at the time of the shooting. He ended up pleading guilty, though, as an adult, to one count of assault with a deadly weapon in exchange for probation. He was also told to go to counseling, to not touch a firearm. I mean, given that this was a felony charge, yeah. And cannot associate with street gangs. And the district judge, Tara Clark Newberry, also warned Joshua Estrada that if he violated the terms of his probation, there could be serious consequences. She said, quote, "I'll give you one chance on probation. One, this isn't juvenile probation," which he's been on, by the way. Yeah. So it's not that the court system is going to give him one chance. He had that one chance as a juvenile. And he got probation for his juvenile crimes, right? And now that he is, well, not convicted, but now that he has accepted responsibility for shooting a man outside of a CVS pharmacy, he gets probation again. The prosecutor in this case, Rachel O'Halloran, told the judge that Estrada had, quote, violent tendencies in the past for no reason, and must be subjected to therapeutic evaluation to, quote, get to those issues. Yeah. His defense attorney said that, well, listen, he's done community service at a boxing center. He's currently working full-time for a construction company. He's been trying to get away from the environment that he was living in, changing his ways, and he has nothing but potential going. That's great. And, listen, on the one hand, it would suck if all of that progress was derailed because he had to go to prison. On the other hand, I think it kind of sucks that you can shoot a guy on the Las Vegas Strip and walk away with probation. At the same time, Democrats in Nevada are clamoring for more gun control laws. I think that kind of sucks too. Listen, I hope that Mr. Estrada can turn his life around, but I don't believe that working a full-time job and doing some community service absolves him of the consequences of his actions. And fortunately, I'm not a judge in Clark County, Nevada. And what I think doesn't matter. Young Mr. Estrada is on probation and will not have to go to prison after shooting a man on the Las Vegas Strip. All right, today's armed citizen story from Freeport, Texas, where police say a homeowner shot and killed a suspected burglar. This was just after 11 p.m. The Freeport Police Department got an emergency call from a woman who said that multiple people had broken into her home. When officers got there on the scene, 3 of them apparently had fled from the home. 2 of them remained at large. The homeowner ended up having to go to a local hospital where he was last known to be stable. The Freeport Police Lieutenant Corey Brinkman says upon arrival, officers located an individual across the street that appeared to be suffering from a single gunshot wound. That subject's been identified and is believed to be one of the 3 intruders that exchanged gunfire with the homeowner. The 27-year-old from San Antonio, who's one of the 3 suspects, taken by air ambulance to Houston with a gunshot wound to the abdomen, but he was pronounced dead after arriving at the facility. Police say that the homeowner was also apparently injured, but not severely. He is expected to recover. They say they don't yet know whether or not the homeowner and the suspected burglars had any relationship before the incident. But right now, homeowner not facing any charges. Police believe this to be a case of self-defense. We'll let you know of any updates as they become available. But 3 against 1. Why would you possibly need more than 10 rounds in your magazine? Right? Why would you? Come on. The average defensive gun use, less than 3 rounds are ever fired. So why would you need more than 10 rounds? Well, because you might very well be facing more than one assailant. If nothing else. But again, it's not a matter of need. These magazines are in common use. We've got hundreds of millions of magazines that can hold more than 20 rounds in this country. They are protected by the Second Amendment. So these magazine bans don't fly to begin with. But again, next time somebody asks you, well, what do you need? You can point to a case like this because criminals don't fight fair. Honestly, they're fine with it being 3 against 1, 4 against 1, 5 against 1. They're fine taking on an 80-year-old man while they're in their 20s. Criminals don't fight fair. And you need to be able to fight back in self-defense. Finally today, our good deed of the day in the right place at the right time, willing and able to do the right thing. This is bizarre. I think that this is the first week that I have covered a story of Good Samaritans pulling people out from underneath a car. A couple of days ago, we had that story where a great-grandmother and her 3-year-old great-granddaughter were pinned underneath the car. A guy had backed up over them, basically. And Good Samaritans and local police were able to extricate both the toddler and her great-grandmother. That was in Florida. Believe it or not, we got another case, this one out of California, where officers and Good Samaritans rescued a cyclist who ended up trapped under a stolen car. Yeah, this was in Watsonville, California. Watsonville Police Department says the driver of a stolen car jumped from the moving vehicle and then ran when officers tried to pull him over. They said the moving car then struck the cyclist and wedged him underneath. I mean, absolutely unbelievable. So again, thankfully, there were officers right there because, well, they were, trying to stop the suspect in the stolen car. Once the car ended up pinning the cyclist underneath, several officers immediately respond, trying to lift the car. One officer ends up saying, I don't think it's going to help. More are yelling, lift, 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 lift. And then other bystanders run over. And basically that's what it was. It was just, muscle power on the part of these officers and Good Samaritans who were able to lift the car up enough, just enough, that cyclist could be pulled out by one of the bystanders. According to police, within minutes of the crash, the 22-year-old driver was arrested. So if he was hoping to use this as a distraction, it didn't work. He now faces multiple charges, including possession of a stolen vehicle, reckless driving causing bodily injury, as well as evading a police officer with disregard to safety. The 65-year-old cyclist is now in stable condition, and the Watsonville police says would like to personally thank the Good Samaritans for their willingness to help a complete stranger. They don't know who they are, so they're asking the public for help in tracking down those Good Samaritans. Again, in the right place, at the right time, willing and able to do the right thing for a stranger in need. Now, that is all the time we've got for you on this edition of Bearing Arms Cam and Company, and this will be the last before Christmas, so I do want to wish you and yours a very Merry Christmas. We will, I'm thinking 95% confidence that we will have a Bearing Arms Cam and Company next week, December the 30th. Look for that. We'll probably be taking a look back at the year that was for the right to keep and bear arms, as well as a look ahead at what we might expect in 2023. So again, look for that next week. I will be mostly on vacation, but the website will be updated throughout the weekend and the week to come. So I would encourage you to visit bearingarms.com. If you like what you see, also, I would encourage you to become a VIP or VIP Gold member. All you have to do, go to bearingarms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. As I was saying, thanks. We're going to give you exclusive content, news stories, and analysis you won't find anywhere else, because your support really does matter, and it really does make a difference. So thank you again. All right. I guess that music means it's time to go, but I do wish you, again, a very Merry Christmas. I'll talk to you before a Happy New Year. So until we talk again, be well, be safe, and be free.